I will start with the problem of asymmetric information in online transactions and how the current regulatory framework deals with this issue. And well, we will see that in those so-called peer-to-peer transactions, this regulation may not apply. And then the question arises, how do we deal with this gap? How do we address this gap? And the argument that I want to make today is that the current regulatory framework is basically based on a two-party transaction between a business and a consumer. Maybe in the future we should take into account that we have three parties now, that we have to take into account the existence of a third party, the platform. And I will discuss two important roles that these platforms can play. First of all, with regard to the information that the platforms have to provide or may have to provide to their users. And secondly, and this is something that we have talked about already today, with regard to the reputational feedback systems they provide, so the innovation they provide. So let's start with asymmetric information. I think you all know the idea of a market for lemons. Basically, it goes like this. Someone who sells a used car has more knowledge about that car than the buyer does. The smart buyer knows that the seller will probably take advantage of his lack of knowledge. And he knows that there are a lot of bad cars in the market, so-called lemons. But he is unable, because he doesn't have enough information, to determine which cars are good, which cars are bad. And well, because of that, he will not want to pay a premium price because there's a risk that he buys a bad car, and so he will pay a lower price. On the other hand, if the seller knows, if the seller knows that he has a good car, he has the information, he will not want to sell his car at a lower price. So the seller with a good car won't sell his car, and in the end, what is left in the market is only bad cars. That's the market for lemons. So the idea is that asymmetric information may spark adverse selection, may spark moral hazard, and this could ultimately lead to the collapse of the complete market. Now, in online transactions, there is a similar risk for asymmetric information. Why is that? Well, because the parties are not simultaneously physically present, and so there's a risk that there is asymmetric information, and our consumer regulation wants to deal with this issue by imposing mandatory information duties on the suppliers who have most information. So professional suppliers have to provide information to consumers. Now, with the emergence of the so-called sharing economy, collaborative economy, well, this makes things a bit more complicated. On these collaborative platforms, the capital P on my slide, such as Airbnb, BlaBlaCar, everyone can provide goods and services. And well, these platforms, they facilitate so-called peer-to-peer transactions. It's not quite sure whether these peers qualify as a business or as a consumer, but it is likely that some of these peers do not qualify as a business. And so these peers, these individuals who provide goods and services, they will not have to comply with the same information duties. And the question arises, well, where does that put us? What can we do about it? Is there a risk that we get to a market for lemons in the collaborative economy? Well, I don't think so, and there are two reasons for that. First of all, there are a lot of studies that suggest that consumers do not read all the information they get, simply because it's an overload on information. There's too much information. And there are other studies that show that even if those consumers read the information, well, they don't understand it, so they don't make better decisions. So basically you could say, well, these information duties, they don't work at all, so it's no problem that they don't apply to these peers in the sharing economy. Second argument, and that's what we're talking about today, of course, are the platforms. In the introductory movie, this is what Rachel Botsman showed. 3 reasons to make the shift from her idea of trusting institutions to trusting strangers. And trust the idea, trust the platform, trust the user. In my opinion, the most important part is trust the platform. We trust strangers because we trust the platform, because we trust that the platform will take care of those strangers that we can't trust. And so that brings me to my first question. If these platforms are so important for the collaborative economy, for the economy in general, why do we impose duties on suppliers and not on these platforms? And to take the example of the Consumer Rights Directive, we could ask the question, do these platforms themselves have to provide some information to consumers? So if we look at the Consumer Rights Directive, there is no specific article on intermediaries. And this was different in the original proposal for the Consumer Rights Directive. There was an Article 7 in that proposal. We stated that an intermediary, and this intermediary, according to the considerations, does not include a platform, but that's a platform in the narrow sense of the words. In my opinion, this does not include all the collaborative platforms, but in any case, an intermediary has to provide information to consumers. What information he has to disclose: that he is acting as an intermediary, that he is acting on behalf of another consumer. And very important, if the intermediary does not comply with this obligation, he is deemed to have concluded the contract in his own name. So if you don't say to the consumer, I'm acting on behalf of another consumer, you won't be protected by consumer regulation. You, as an intermediary, will be considered to be the contracting party. You will have to comply with consumer regulation. Now, this article was not retained, so it's not in the Consumer Rights Directive. We've seen already, Professor Voineau discussed this, that in France there was an information duty introduced that specifically addresses platforms. A platform has to provide information, and one of the information duties has to provide information about the capacity of the advertiser, and especially has to provide information on the rights and obligations of contracting parties. But the question arises: do we need such a specific information duty for platforms, or maybe we can do it? If my slides, maybe that's not necessary. If you take a look at the business model of the sharing economy, well, there's one party of which we can definitely say that it's acting in a professional capacity. That's a platform. And to the extent that these peers qualify as a consumer, and the relationship between the platform and the peers, well, it's a B2C relationship. And so in those two relationships, the platform has some duties as well. If we look at the Consumer Rights Directive, if you enter into a contract with a consumer, you have to provide information. And what is, for us, I think, especially interesting is that the platform has to provide the consumer with the information on the main characteristics of the services it provides. If a platform argues that it's acting as a facilitator for C2C transactions, it has to disclose this to the consumer, because it's the main thing that the platform does. Now the question arises, so we see here to some extent, I think, an obligation that is that looks like Article 7. The platform has to disclose that it's acting as an intermediary, acting as a platform. But what about the sanctions? What if the platform does not comply with its obligation to provide information, to disclose to the consumer that it's acting as an intermediary? And the Consumer Rights Directive doesn't provide a specific sanction for that. And if we, it refers to national law. If we look to Belgian national law, there are no specific sanctions in our Code of Economic Law, no specific sanctions. We can consider this to be misleading omission. It may be a breach of pre-contractual duties, or there's liability. We may consider this to be a vice de consentement, so that the contract is void, but there's no specific duty. And I think it's an interesting question whether it would be able to somehow construct the same sanction that was in Article 7. Could we hold the platform liable if it doesn't provide the consumer with information about what it's doing, about the fact that it's acting as an intermediary, and about the fact that the consumer will not be protected by our traditional information duties? Now, if we look at Article 3 of the Consumer Rights Directive, we may think that's not possible. It's specifically said that the directive doesn't affect national general contract law, and in the considerations it's specified, especially not those laws on legal representation. So based on the Consumer Rights Directive, we could say, well, that's not possible. But some recent developments in consumer sales law provides an interesting perspective. And we had a case in Belgium already in 2010, where a consumer bought a used car in a garage. And well, after a couple of days, and I come back to my first story, he notices it's a lemon. It's a bad car. So he goes to the garage and he invokes his rights, his consumer rights. He says he wants to make use of the legal guarantee. But the platform says, well, sorry, but I was merely acting as an intermediary for another consumer. You are not protected by consumer regulation. And, well, the Court of Eupen did not follow this reasoning and said, well, without much further explanation, it said, well, even though you are acting as an intermediary, you can be considered a seller, and we do apply consumer regulation. And this decision was heavily criticized in Belgium. Why? Well, because it really doesn't take into account, it doesn't say anything about the principle of legal representation, so it's a bit strange. But another case with very similar facts provides an interesting perspective, and that's the Wathelet case. So again, in Belgium, a consumer, Sabrina Wathelet, buys a car at a garage, Biteret, and well, after a couple of months, it turns out to be a lemon, a bad car. So she goes to the garage, same fact, and ultimately she invokes her consumer rights, and the garage says, well, look at your contract. If you take a look in the contract, you have signed an agreement with another consumer, even though you didn't saw that consumer, I didn't tell you, but it's in the contract. I mean, you signed this contract, so you signed the contract with Ms. Dunkels, you can't complain to me, you can't invoke your consumer rights against me. And in first instance, the court decided, well, Sabrina Wathelet lost the case. Why? Well, because of the principle of legal representation, the garage was merely acting as an intermediary. But in appeals, the court wasn't so sure, so a preliminary ruling of the Court of Justice of the EU was asked, and in November 2016 we had a decision of the Court of Justice in which it decided that the concept of seller in the Consumer Sales Directive does include intermediaries who do not inform the consumer of the fact that they're acting as an intermediary. So basically, based on this decision, you could maybe apply the sanction of Article 7, meaning considering the intermediary to be the contracting party, but of course this is in consumer sales law. The question arises, can we apply the same idea in other, for example, for other directives, for example, for the Consumer Rights Directive? And according to the Court of Justice, you can't. The concept of seller is a unique concept. It has to be interpreted within the context of the Consumer Sales Directive. And, for example, the concept of trader in the Consumer Rights Directive, well, that's a different concept. Now, even if we would follow this argumentation, I'm not that sure that you could not apply the same reasoning that the court did to other directives. And even if you only take into account Belgian contract law, we might be able to come to the same conclusion. Because for a mandate to be valid, the intermediary has to disclose to the other contracting party that it's acting in the capacity of an intermediary, that it acts on behalf of another person, and it's not sufficient to do this in your terms and conditions. You have to actively inform the other party, and if not, well, the sanction is that you're engaging in the contract in your own name, so there's no mandate. So that brings me to my first conclusion. If these information duties do not apply because we're in peer-to-peer contracts, is that a problem? Well, not so much, because at least as a consumer you will know that you don't have the same protection. Why? Because the intermediaries have to inform you of the fact that you're not protected, and if they don't do so, they may be liable. Now that brings me to my second point. Is it a problem that consumers will not have the same amount of information because the suppliers may not have to disclose all the information? And here I think the collaborative economy introduces an interesting alternative with the review systems that we have already discussed to some extent. And it's more than only review systems, it's technology, for example, GPS tracking in transport, in the transport sector. It's even Twitter using social media to know whether the other party can be trusted. But of course, reviews are very important, both reviews on the collaborative platforms themselves and on other websites such as TripAdvisor, Yelp. And this is something that Professor Bush already said. Some scholars are very positive about this and say, well, this is it. We don't need anything else. Technology solves everything. We don't need further regulation. But of course, and we heard various examples today already, these systems do have their flaws. And some of these flaws are inherent to the system. Several studies show that people with extreme experiences, be it extremely positive or extremely negative, they are more likely to write a review than those people who have a normal experience and don't feel the urge to really do that. On the other hand, those people that engage into a contract, they have read the reviews of other people already, so they are more likely to like the product, which is a good thing for the person entering into the contract. But of course, if he then writes a positive review, in the end you have more positive reviews than negative reviews. And this leads to what, well, literature calls a J-shaped distribution, as you can see the blue line of reviews. So most of the reviews are extremely positive, some are extremely negative, but there's not that much in between. So those are the flaws, some flaws that are inherent to the system. But then, of course, we have manipulation by the system. And according to a report of the UK Competition and Markets Authority, there are two main forms of manipulation. First of all, businesses writing fake reviews positive about yourself, negative about others. And then another thing, and that's something that we have already discussed extensively, it's manipulation by the platforms. This can be very subtle, for example, showing more positive reviews on the first pages or not publishing negative reviews at all. So with regard to this first problem, the fake reviews, the question arises, what do we ask from the platforms? Do we want these platforms to intervene against fake reviews? I think we do. The question is, do we need the law to do that? Do we have to have some rule that obligates platforms to do something about fake reviews? And a big argument in the US is that we don't. And why is that? Well, because the platforms do have an incentive that these reputational feedback systems work. And Rachel Botsman said it. These platforms know that trust is key in their business model. Trust in their platform is key in their business model. If the reputational feedback system doesn't work, well, their business model is done. So the argument is basically let market forces play their role. But personally, I'm a bit afraid that market forces cannot fully play under the current regulatory framework, both in the EU and the US. And why is that? Well, because of the liability exemption of service providers, I guess. So the liability exemption of Article 14 of the e-commerce directive. Basically, it means that as a provider, you are not liable for the information you store on the request of other parties. And, well, basically, the main condition for this liability exemption to apply is whether you, the provider, have actual knowledge of the illegal nature of the content, meaning whether you play an active role or not. And if you apply this idea to those platforms that provide a reputational feedback system, you come to an absurd situation, in my opinion. Those platforms that don't do anything, they're passive, they are treated favorably. They cannot be liable, the liability exemption applies. Those platforms that do something, well, then the question arises whether or not they are playing an active role. And if you would consider some activities to do something about fake reviews as playing an active role, well, then you're treating those platforms that do something about the problem less favorably than those platforms that don't do anything. And I think that's absurd. Now, the European Commission doesn't agree with me. In a recent communication on the European Agenda for a Collaborative Economy, they say that maintaining this liability exemption is key for the economy. But at the same time, they say that, well, they want to encourage responsible behavior, they want platforms to take voluntary action, and this is very important, the fact that these platforms take voluntary action should not automatically mean that they don't fall within the liability exemption of Article 14. Now, I think that's an interesting interpretation. I'm not sure whether it's enough to do this in a communication and whether this interpretation really complies with the text of Article 14, but maybe there's some support in a recent decision of the German Bundesgerichtshof that Professor Busch already discussed, because there it was decided that the fact that a platform, I think it was a hotel review site, that the platform applied an automatic words filter to check whether some words comply or not with their terms of use. The fact that they use these automated systems, well, this does not mean that the platform is acting actively, has actual knowledge of the information stored. And so this reasoning, well, at least it doesn't treat those platforms that do something with automated system less favorably than platforms that don't do anything. So next to the fake reviews, there's of course the liability by platforms. I will not discuss this because, well, all the speakers before me have addressed this issue already. I like the idea of imposing a general duty on platforms and leaving the rest to the market. And I think, and this relates to the discussion that we had before, whether there should be law that obligates platforms to take some voluntary action. I think we should somehow find a system that creates an incentive for those platforms to really take voluntary action, and then we may not have the situation that platforms, well, they want to do whatever they want. Maybe if there's uncertainty about their liability, they will want to adopt voluntary standards simply because there's more certainty that they are not liable. I don't know. Now that brings me to my final conclusion. These traditional information duties, they probably don't apply in peer-to-peer transactions. Is that a problem? Well, probably not. First of all, the platforms, they will inform the consumers about the fact that they are not protected by consumer regulation, and also these platforms provide some review systems that present an interesting alternative to these information duties. But then of course we have to make sure that our law doesn't create incentives for platforms or takes away incentives for platforms to make sure that these review systems work properly. Thank you for your attention.
Thank you very much, Bram. I think that complements the first presentation by Denis.